So welcome to the Commercial Law Panel, which is the last in the Explore the Bar webinar series. Now, this series was developed by the Committee for the Association of Gray's Inn Students and also the Education Department of Gray's Inn. The panels were created in order to give the students a chance to know more about the different areas of law in practice from barristers who are currently practicing in those areas. Given everything that is currently going on, we do understand that it has become much harder to obtain experience and get involved with anything you can in the area of law that you would hope to practice in one day. So we did think that we should take advantage of the benefits of the virtual world that we must now adapt to. And one of those benefits is that we are able to host this virtual series of webinars for you, which is open to individuals to watch and engage with from any location. Now, before we introduce our panelists, please could I ask that any questions are submitted to the Q&A chat box. Please feel free to ask any questions as we go along, but we will answer them in turn towards the end of the panel. Now, let's meet our panelists. So today we have Chantal Steining, Seth Kitson, and Nora Vanagat. Now, to begin, please could our panelists please provide everyone with a brief introduction about themselves, starting with Chantal.
Hi, so I was called in 2012 and I did pupillage at Erskine Chambers and became a tenant there in 2013. I have a slightly unusual journey to the bar in that I did an English degree at university and I was then a theatre producer for 5 years. And I was 30 when I started pupillage. So I was perhaps a slightly more mature applicant and pupillage candidate. My specialism is company law and insolvency, so I'm more the commercial chancery end of this commercial discussion.
Thank you, Chantal. Next we have Seth.
Hi, my name's Seth Kitson. I am a broad commercial civil chancery practitioner practicing in the north of England, mainly Newcastle, Manchester, Leeds area, but I do travel. And I was called in 2017. I completed a pupillage at Deer Street Chambers, who are in Newcastle and York. And yeah, as I said, my practice is still fairly broad, but I do commercial work and then what you'd call traditional chancery, so quite a lot of land disputes and things like that.
Thank you, Seth. And now Nora.
Hello, I'm the most junior one out of the three of us. I was called in 2018 and then I did pupillage from 2018 to 2019. So I've been a tenant for almost a year and a half now at Nine Stone Buildings, which is also where I trained. I've also got a slightly unusual route to the bar in that while I did come straight from university, I did everything before university in Germany, where I'm originally from.
Thank you, Nora. Now, Chantal, could you please provide us with a brief overview of the main areas of commercial law for those who are fairly new to this area?
Sure. I mean, I think it encompasses a broad range of practice areas. You have the more pure commercial disputes, which are often contract law based. But there are also sets, for example, that specialise in shipping. There are commercial sets that have some crossover with international law and EU law. There's competition law, which sometimes falls under a commercial law banner, or there can be overlap between that. And then chancery, which is also a form of commercial law. It was traditionally a bit more trusts and equity based, but now overlaps to a very large degree with the kind of work that a lot of large commercial sets will be doing. So I will often be in court against members of more commercial sets rather than chancery sets. And chancery work will include the slightly more traditional end of chancery, which is trusts and estates and will work, often about individuals. Bankruptcy, which is again more about individuals. It also encompasses property disputes. And then you have the more commercial chancery end, which is my area, which is a lot of disputes involving companies, shareholders, directors' duties, and insolvency, which again overlaps with a lot of company work because you're often looking at the rights of members and creditors when a company becomes insolvent. So it's a huge range of work, and my recommendation really would be to look at the sets you're interested in and see what areas of work they do, because the description of commercial, civil, chancery can really involve very different areas of work depending on the chambers that you're looking at.
Thank you, Chantal. That was a very good overview of all the areas of commercial law. Now we will move on to our first area, which is about your journeys to the bar. What brought you to the law, firstly, and secondly, why did you decide to pursue commercial law? We'll go with you first, Seth.
What brought me to wanting to practice in commercial law was I wanted to practice in an area where I'd get to use some of the things I learnt on my law degree, so some of the sort of black letter law that you study at university, an area where I wouldn't necessarily be in court every single day, and would be able to do more papers work alongside that to have a better, or try and have a better work-life balance than some of my colleagues who are, do say criminal or family, who would be in court every single day, getting their brief at 9 p.m. the night before or whatever. In terms of why I wanted to come to the bar, I mean, broadly the same things. I wanted to use the law, apply it. I wanted a career that was involved engaging with other people and a sort of human element more than just an office-based job or an office-based legal job.
Thank you, Seth. Now, in regards to the pupillage process, Nora, you are the part of the junior counsel. So can you give us a brief outline of your experience when you were applying for pupillage and your journey through the pupillage application and interview process?
Yes, so I first sent off a couple of applications during my master's. But I was quite unfocused, I think, at first in my approach because I really didn't know yet which area I wanted to go into. So I think I applied to something like 7 sets, and they'd include common law sets and they'd include construction law sets. And predictably, that didn't go particularly well. So I got, I think, 1 first round interview doing that. And then sort of over the summer, I decided I was going to get a bit more serious and, you know, get a bit more focused. So I went to the careers advisor at ULaw where I was doing my bar course, and she had a list of chambers that weren't on the gateway, some of whom had very sort of early application deadlines. I saw one in particular that had an application deadline in September, so I think about 2 or 3 weeks away from that appointment. And I thought, well, I should at least give it a go, because essentially she'd looked at my CV and said, this looks like chancery. Which, looking back, that probably makes a lot of sense because I did a master's in international commercial law. I did a dissertation as part of that master's on a comparison between German and English trusts. So I then submitted the application that was due in September, got a single round interview and got pupillage. So I was actually, I think, quite lucky in how fast that whole process worked out. Once I'd actually decided on what I wanted to do, I only went to 2 pupillage interviews in total.
Wow, that's fantastic, Nora. Thank you so much for that. Now, Seth, I know that you were called to the bar in 2017, so could you possibly provide us with some details as to how your pupillage year looked like?
Yeah, so different chambers will do different things. The chambers I was at, we're not just civil commercial, we also have other disciplines as well. I had 1 pupil supervisor through my whole pupillage, and for the first 6 months I spent a lot of time in chambers with him, researching points of law, helping him prepare for trials, attending the trials with him, taking notes, as you'd expect. Occasionally, you know, making a cup of tea if he looked like he was flagging, and just generally trying to get myself involved in chambers life and meet as many people as possible. Different chambers may rotate you through different pupil supervisors, but that's largely what my year looked like. Quite a lot of time in chambers, so probably I spent at least 3 days a week sitting in chambers with my supervisor, reading through practitioner textbooks, looking at pleadings, researching points of law, and the other 2 days a week would be in court, or I'd go and follow someone else sometimes if they had an interesting case. And then in my second 6, to begin with, I actually practiced also in across all 3 areas, because I'm at a common law set. But after only a couple of months, I dropped doing crime and did not very much family work at all, and just concentrated on the civil. I did a lot of injunctions to resist winding up petitions, a lot of very small scale partnership disputes, things like that, and just sort of knockabout stuff, which is a great learning experience. Towards the end, I started to do some sort of bigger cases, and I would junior with my pupil supervisor in a couple of cases towards the end, and then just kind of carried on from there. So I mean, that was the shape of my pupillage, really. I think fairly atypical. If you were at a commercial set, I imagine what they do is pass you around, or a pure commercial set, you probably get passed around 2 or 3 different practitioners. Where I am, there's only about 3 or 4 commercial practitioners in the set, so it just made sense for me to stay with one mostly.
Thank you, Seth. Nora, could you tell us what your pupillage here looked like?
And first of all, I love my pupillage and can definitely recommend the experience. But in practical terms, I had 3 supervisors, and I was with 2 of them for 3 months each, and then one of them for the last 6 months, basically because I requested it, because his work was really interesting and we got on well. Other than that, I suppose my pupil supervisors had quite different practices. The first one was quite senior, about 60 years old, and he did a bit of everything. My second one did only land and village greens, which was a very interesting sort of niche area to get a look in. And my third one was more of the on the commercial and insolvency side of things. And I did get to do quite a bit of advocacy, which I think can be quite atypical for chancery and commercial sets. But I did some application hearings in my second 6, and some smaller trials, a couple of road traffic accident trials, which I think they were sort of giving me so that I'd get some advocacy experience, and bankruptcy petitions, things like that.
Thank you, Nora. Now, Chantel, what advice would you give to someone like ourselves, students who are applying for pupillage currently?
Sure. I mean, I think that the very general points first, which partly follows on from what Nora said about her choice of chambers, is be open-minded to some extent about where you apply. Talk to practicing barristers if you can. Try to get to know the culture of the sets, because you may very well be happier somewhere that you haven't yet thought about applying. And also try to be slightly open-minded about practice area. Lots of applicants have a very fixed idea of the practice area that they want to do. And they also sometimes have a very fixed idea that they want to do a general practice early on, and that they may then be able to specialise at a later stage. That may work out, but there can also be advantages to considering more specialist sets early on, because the quality of work often is very good. And it's interesting that Seth was saying that he seems to have specialised within his set from quite an early stage. More generally as well, do talk to the education department and use the opportunities provided by the Inn for mock interviews and feedback on application forms, because there are lots of barristers at the Inn who would normally be getting to know the students right now, and we're always very happy to talk informally and to give advice and feedback on your applications, and generally to provide support. And I know it's difficult at the moment, but Gray's Inn is a fantastic resource with very supportive barristers, so please do use it as much as you can. If you get to the interview stage, I've interviewed our pupillage candidates for probably the last 5 or 6 years. And the best candidates are the ones who really think about their answers. So if you're in an interview, do pause before you answer a question if you need time to think. Don't feel under pressure to answer immediately, and really listen to what you're being asked. And if you don't understand what you're being asked, then please ask for clarification, because as a panel, we want to get the best out of you, and we want to identify the best candidates. And sometimes that's quite difficult to do when people are nervous in an interview situation. And try to stay calm during your interviews, because you're really not always the best judge of how they're going. If you're performing well, then you might be pushed more by the panel to explain your reasoning and to think around your answers. And they want to see how you think on your feet. So even if you think there were some difficult questions there and I don't know how well I answered them, to some extent that might be a reflection that they thought you were a good candidate and they were trying to push you. As a quite a specific piece of advice, we use a legal problem as part of our interview, which quite a few of the commercial and chancery sets do. And when you get the legal problem, there will often be several possible answers. Often the best approach to that is to set out to the panel why you've taken a particular view, but also to acknowledge the arguments against, and explain why you nevertheless have considered those, but think that your view is the better one. And remember that the panel is never really looking for right answers. We want to identify the lawyers who can see different sides of a problem, but can also come out with a considered view and advice on what their view would be. And I sometimes say to people that think of it as though you're in a conference advising a client. You'll never really have an open and shut case. You'll be talking about what the weaknesses of that case are, but you will also ultimately have to give your professional opinion on what the answer is. And if you think of it like a conference, then I think sometimes people are unsure about how much they should defend their position, and how much they should acknowledge that they might have got something wrong. And I think the answer to that is that if you're not persuaded by something an interviewer is saying, defend your position. But if you realise you've got something completely wrong, then say so. There's nothing wrong with acknowledging that a strong point has been put, which has changed your view. And really that's what happens in practice every day when you're in conference with clients or solicitors. So that's some slightly practical legal advice. Seth and Nora are probably better placed than I am to give more general, up-to-date application advice.
Nora, Seth, either of you volunteering to give us even more, because that was outstanding, Chantal. That was brilliant advice, and I'm sure the students are going to be so grateful for that.
I'd probably just say one thing on top of that, which is it specifically relates to commercial chancery sets, is look at the profile of the people that these sets take. There are certain sets who are looking broadly for candidates who have a general, will have a similar educational background. Now, you can always be someone who bucks the trend, but I had a lot of contemporaries who applied to sets who I think if they'd looked at their CVs and then looked at the CVs of the people there, might have thought, well, actually, I could go there, but maybe I should go and try and do the BCL first, or I should try and do something else, because actually at the moment, you know, my 2-1 from a good red brick university is probably not going to get me in the door there. I need to do more. So I think look at the people that they've hired recently, that they've taken recently rather as tenants, and look at how your CV sort of compares, and don't waste choices on applying to sets where you won't get an interview, because unfortunately I think that does happen sometimes. I mean, it might be that Nora or Chantal thinks radically different and I'm being too pessimistic, but I do think having a sense of realism about where you're applying it is sensible.
Thank you, Seth. Now moving on to the second area, which is day-to-day practice. Nora, what does your working week look like?
It's kind of difficult for me to say because I'm sure it's the same for Seth and Chantal. It's always different. I would say that I tend to be in court quite a lot for a commercial and chancery practitioner, but I do a lot of short hearings. So I tend to be in court 2 or 3 times a week. And then I tend to spend the rest of the time drafting pleadings or drafting opinions and having conferences. So that's essentially it, although, yes, I mean, it is always different. For instance, I've got a 4-day trial coming up in February, which means you'll spend a couple of days just preparing for that. And obviously almost the entire week just going to that. But I do think it's a good mixture in this practice area.
Thank you, Nora. Now, Seth, how has your practice changed since you first qualified?
So probably the biggest change is I think I've started to have more ownership over the cases in my diary. So when you first get on your feet, realistically, very few people, unless you're truly a superstar, are going to be ringing up your chambers saying, I want Seth Kitson for this case. What you're going to do is you're going to get the cases that are returned into chambers, or maybe that your supervisor can't cover, or maybe they're just cases that get sent into chambers by solicitors who send a lot of work to your chambers. Probably the biggest difference between when I first started and now is that most of the cases I have are cases that I've had since the beginning. You build working relationships with the solicitors, so the cases I've advised on, drafted the pleadings, done the preliminary hearings, and then eventually do the trial on them if they reach trial. So it's probably that, and with that comes a shift in more papers. So like Nora was describing, when I first started, and I'm not that much further ahead than Nora, but when I first started, I was in court a lot, doing applications, injunctions, kind of shortish half-day hearings all the time. I still do those because that's your sort of bread and butter work at the junior end. But more and more, I'm out of court probably 3 days a week, or at least 2.5 days a week, doing papers, having conferences, advising, researching, that side of the practice. My experience, at least, was that bit takes a little bit longer to build up because it takes solicitors trusting you and wanting your views on things. And you only develop that relationship by going and doing the initial hearings for them, or meeting them in conference with your supervisor or whatever in pupillage, and striking up a relationship. So that's probably the biggest change. I spend less time in court, but I've got a bit more ownership over the cases that I do.
Thank you, Seth. That was very informative. Now, Chantal, could you also tell us a bit more about how your practice area has changed since you first qualified?
Sure. I mean, I think I endorse everything that Seth said. I mean, at the very start, you have very little control over what you're doing, and you take the work that comes in. I completely agree with Seth that the way you build up your practice and the way it changes is that you start to build relationships with solicitors, and you do work well, and you become more specialised and more experienced in that area of work. And sometimes you're able to direct it to some extent, but sometimes that's just an accident about the kind of work that you get in, and you get a reputation for it, and you do a case that means other people want to instruct you in that kind of work. I mean, for me, I spend quite a lot of my time still being a junior on more high value, complex trials. And that's just because of the nature of the work that they often want a QC to be leading the trials. But I've gradually had more cases where I've been sole counsel. And there's enjoyment in both of them. I like being part of a team and being a part of a team with other members of chambers, but it's also quite fun to have the responsibility yourself. I've also gradually started to do more advisory work. where I have relationships with solicitors who will ring me up fairly regularly asking for advice, or companies wanting to know whether they can do something, which I actually really enjoy, because that is a lot of the time the black letter law. So I think it's a real mixture of when you get work, doing it well, but also the accidents about what work you get, and that's really what ends up developing your practice.
Thank you, Chantal. Now, Nora, how have you been able to direct your career, or rather develop areas of specialism?
Well, not that much yet. So I should have probably said at the start, I kind of do everything that falls within Chancery and commercial work. Although I am quite interested in insolvency, as well as commercial work. So I'm moving away from land law a bit. That doesn't mean that I turn down any land law cases. I'm not really in the position where I do that. And I'm not really in the position where I'm particularly known for anything yet. But I have sort of started to establish some relationships with solicitors firms who do a lot of insolvency. And so I think I do gradually manage to steer things a bit in that direction.
Thank you. Seth, seeing as you are slightly, you've been at the bar slightly longer, have you been able to develop a specialism, or when does that actually happen? When do you actually start to develop areas that you want to specialise in as such? Seth, you're on mute.
Yes, I'm basically in the same situation as Nora. And to be honest, probably the one of the biggest differences between myself and Nora and Chantal is because I practice predominantly on circuit, so up in the north of England, northeast and northern circuit. I will specialise as I go through. So, you know, at the moment I do everything like Nora that falls under the bracket of commercial chancery. I will probably drop some elements of that as I go along, but I will probably in all reality remain much broader, just because the nature of there is less commercial work up here, and the solicitors who brief me will want to be able to brief me on a kind of broad range of things. I think if you practice in London, I mean, you can obviously be a broader practitioner in London, but if you want to specialise, it seems to me that there's more opportunity to become a real expert in a certain niche area if you're practicing at a specialist set within London. That has changed a little bit, because obviously now we have the business and property courts, so Newcastle, Leeds, Manchester, they all have their own district registry of the High Court that sits. So a lot of the work now, theoretically, if it's got a link to an area, should stay there. But yeah, I'm pretty much the same as Nora. I haven't really started to steer things massively. I don't know if I could if I tried, and I just do what I get sent or what people ask me to do.
Thank you, Seth. I'm going to pass you over to Mariam now.
Thanks so much. That was really good answers from all of you. Thanks, Seth. Now let's talk a bit more about commercial law development. So Chantal, how have the commercial courts responded to COVID-19? You know, what's the situation with that?
My experience is that we have been relatively undisrupted, because the courts moved fairly quickly over to remote hearings. I think my first remote hearing was a case in the Supreme Court last April. I think we were only the second remote hearing they'd done, which was quite nerve-wracking, but worked fairly well. And I haven't had an in-person hearing now since COVID and the lockdown. I think that the courts had started to get back to non-remote hearings for trials, and certainly some trials where there might be very heavy witness examination and there might be particularly long trials have been adjourned. But the commercial courts, the Chancery Division is trying to keep moving and trying to use remote hearings as much as possible. And it may be that actually remote hearings continue to be used generally for some of the shorter hearings, which I think is a very good thing, and some judges really like them and think they've worked very well.
So Chantal, thank you for that. Could you give us an insight onto why you think the remote hearings are working very well? Why do you personally, like remote hearings more than a face-to-face hearing, for example?
So the kinds of hearings that could continue to be remote I do quite a lot of very short 5-10 minute applications under the Companies Act. And often they will involve going to court, waiting, and you might be waiting for quite a long time before you're called on, and obviously that costs everyone quite a lot of money. And so generally the unopposed hearings, but that have to go through the court. And they are working very efficiently remotely because you're just given a link to Microsoft Teams for a set time. You log on. I'm finding that they're being done very quickly by judges who know what they're doing, and by counsel who generally knows what we're doing. So it's possible that those sort of hearings might continue to be remote. But I don't know. It may end up depending on the judge and depending on counsel.
Thanks, Chantal. So Seth, could you also provide an insight on this matter? What do you think about COVID-19 and how the commercial courts have responded to it?
Well, I think there was a sort of mock commercial trial up on YouTube almost immediately, wasn't there, to show that it could be done. I can't remember the kind of fictional name they gave it. But yeah, I think broadly it's worked really well. For the reasons that Chantal has said, if you've got a short hearing, it means you're not sitting in the corridor wherever you would be waiting to get on. But the other thing that's quite nice is most commercial hearings, if it is a dispute, are going to be pretty document heavy. And rather than everyone rustling through the pages of a bundle saying, can you get bundle 3? Can you look at tab 4, page whatever? You can just get it up on the screen and everyone's looking at the same piece of paper or electronic piece of paper. You get the witness to read it. You can ask your questions, and it actually can move along quite quickly like that. So I think broadly it works well. I think I do miss the human contact. I do miss sitting on the corridor, having a chat with counsel, waiting to go in and that sort of stuff, because you obviously don't get that as much. But yeah, I mean, broadly it seems to be working well.
Thanks, Seth. So Nora, given that your year of call was a bit later on than Seth and Chantal, how are you finding it? Do you want to go back to face-to-face hearings, or do you find that the way the commercial courts are responding to COVID-19 is something that's going to last a while?
I would definitely prefer to go back to face-to-face hearings in the county court, because I think the county courts have been struggling a lot more than the Companies Court, for instance. So I do think things have been vacated in the county court that would not otherwise have been vacated. And I always get a bit of anxiety about potentially not getting a phone call, because there has been at least one occasion where apparently somebody copied out the wrong phone number and then they called somebody else rather than me and couldn't get me on the phone. And thankfully I had an opponent who emailed me and said, can you just tell us your phone number again? But against the litigant in person, I'm not entirely sure what I would have done. So for me personally, it sort of adds a bit of a layer of stress. While normally, well, in the first 6 months of my tenancy, I felt quite comfortable once I was in court, because at that point, what could go wrong was pretty limited. While now there's a constant, just in the back of your head, a constant question as to whether your phone will kick you out of a conference or your internet will fail or something like that. So.
Thanks, Nora, for that. That was very insightful, specifically the example that you gave. Now, Nora, in terms of recent cases, what would you say is a recent case that maybe in the last year students should be reading up on or students should look out for? What case is there in commercial law in the last year that you'd say is a significant one?
I mean, obviously there are always a lot of cases that, for instance, students could be asked about at interviews. One that I think was interesting is called Re A Company. It's 2020 EWHC 1406 CH, if somebody wants to look it up. So that was one of several cases that dealt with the corporate insolvency and governance bill before it became an act, because there were some winding up petitions where it was relatively clear that the bill was going to become an act, and that ultimately this winding up petition wouldn't go through. So in most circumstances, a couple of companies then made applications for injunctions to restrain the presentation of those winding up petitions. And in those cases, you can sort of see the court dealing with something that they know will become law soon, but isn't law yet. And I think that's quite interesting, because they tended to be successful if they could show that the petition was going to fall within the new test.
Thanks, Nora. Chantal, what cases popped into mind for you when this question was asked?
I think it's quite a difficult question, because actually it's such a wide area of law that there will be different interesting cases depending on what area of law you're applying to. I think that, so from my perspective, insolvency in particular is interesting and will continue to be interesting. If you're applying to a set that is interested in insolvency, there are a number of company voluntary arrangement or CVA challenges in the courts at the moment, which are being brought by landlords who think they've been treated unfairly. So it's worth having a look and being aware of that. The Supreme Court is going to hear the BAT and Sequana appeal, that's SEQUANA, in May, which raises a question about the point at which directors need to consider the interests of creditors when a company is at risk of insolvency. And I think part of the reason why insolvency is so interesting at the moment is that we are going to have more high-profile insolvencies and a lot of litigation arising out of that because of the last year or so. I mean, from a competition perspective, you have the Visa, MasterCard litigation, but generally it's just worth keeping an eye on Chambers news pages, follow people on Twitter, and maybe keep an eye on what's coming up in the Supreme Court.
Thank you, Chantal, especially for the advice at the end and how students can actually keep up with what cases they need to be looking at. So Seth, how about you? What cases would you say students should be familiarizing themselves with that's, come about in the last year or so? Oh, Seth, you're on mute again.
Yeah, I can't really add that much to what has been said by Nora and Chantal. I suppose Canary Wharf and European Medicines Agency, which was a 2019 High Court case, which was in a nutshell about whether or not Brexit could constitute a frustrating event for a lease. That is one which I know probably all Chambers questions now are going to be about COVID as opposed to Brexit. So I might be a little bit out of date there, but certainly around looking at issues around COVID and around people trying to get out of contracts due to COVID and arguing that it's a frustrating event, things like that, I suspect will be something that's going to be relevant for Chambers. And on that, the most recent one I could think of was Canary Wharf. But if anyone knows of a more recent one, I'm sure they'll correct me.
Thank you for that, Seth. Now, Seth, could you also tell us about how you would see commercial law developing in the next 5 years?
Blimey. I'm going to give a very short answer, and then I'm going to suggest that, and it's not a hospital pass, but obviously Chantal is far more experienced than I am, and was flexing earlier with her Supreme Court appearances. So I think she's probably going to be best placed to answer this. Where is commercial law going in the next 5 years? Well, I'm just going to cheat by answering in a very short term. I am seeing a lot of landlords chasing tenants at the moment, and a lot of tenants trying to avoid paying rent in commercial premises all around the north. I assume the same is happening in London. So I suspect there is going to be a glut, especially of these sorts of cases coming in the near future. I mean, some of them are already working their way through courts now. So yeah, I'm just going to give a short-term cheat answer like that and dodge the broader question, because I'm just too young to know.
Thanks, Seth. Well, I'll go straight to Chantal. Chantal, where do you think the commercial law will be in 5 years?
I think Seth's absolutely right to pick up on that, and it ties into the CVA challenges by landlords that I brought up, albeit on slightly different scales. I think we're going to see a lot of litigation. That tends to be the pattern, that often when you have a downturn, you do actually see an increase in litigation, because there become problems with businesses, and there are contracts breached, and there's a lot of arguments about that. And as I said, I think we're going to see more high-profile insolvencies. I think that Brexit is going to continue to be an issue, I'm afraid, for lawyers over the next 5 years. There may still be questions about cross-border cooperation, recognition of cross-border insolvency proceedings, recognition of judgments from EU companies, and we may generally see changes in UK legislation and regulations as a result of Brexit. So it's to some extent impossible to say, but what I do think is that from the commercial bar's perspective, we're very, very lucky in that we're not seeing the same downturn of work as some people in other areas of the bar are seeing. And so it will be interesting to see what happens, and there will be interesting things happening over the next 5 years from a barrister's perspective.
Thank you so much for that, Chantal. Nora, we'd still want your insight on this matter. Where do you think the commercial law will be in 5 years from your experience so far?
I mean, I don't think I can really add anything beyond what Seth and Chantal have said. That all sounded very legit.
Thank you, Nora. So Seth, Chantal, Nora, thank you so much for answering those questions for us. Now I'll move on to answering some questions from the chat box. So first I'll go to the chat box feature to see what questions we have there. So the first question is from an anonymous attendee. It's for Seth. So does the commercial law realistically give you a good work-life balance?
I actually think it still does. So there will be times where it's just awful, and you're in the middle of a trial and something goes wrong, or you're prepping for a trial, or you've got a very tight deadline. But when I compare my lifestyle to my colleagues who practice at the family bar and at the criminal bar, I think I am free to set the pace of my own working week much more generally. Obviously, there will be times where it's busy and it's stressful, but you generally don't get the very last minute briefs where you're having to, getting thrown into a 3-day trial with half a day's notice, and someone's having their children taken away or something like that, and with all the stresses that comes with. So I think, yeah, it can be very stressful, and it's a different kind of stress. But yes, I think broadly you can have a decent work-life balance, at least compared to other areas of the bar.
Thank you, Seth. You're very popular today, Seth. You've got another question for you here. So this question is from Digna. It says, I have heard from quite a few chambers that they encourage you to take a focused approach when applying for pupillage, but I was wondering how that worked with you, given your chamber's wide area of practice. Did you apply having in mind commercial law, or did you specifically choose that set for the opportunity to see different practice areas firsthand? Also, is it common for sets to have a variety of practice areas?
Okay, so this is only going to be a useful answer if you want to practice on circuit. So I knew that I used to live in London, and I knew I didn't want to live in London anymore. I wanted to move up to the north. So when I applied to all the sets kind of up and around Newcastle, Leeds, that sort of area. And the vast majority of those sets, bar kind of 2 exceptions, are going to be common law sets. So I applied for a common law pupillage because that's what the pupillage on offer was. I did make clear that my interest was in civil and sort of commercial law more generally. But you've got to tailor your application to the sets that you're applying to. And because it was common law, I said, and I do think I benefited from seeing a bit of crime and a little bit of family law, and the time, going to the magistrate's court and having briefs thrown at me at the last minute, that was probably quite good for my development. But yeah, I applied to common law sets and then was able to specialise once I was there very quickly because I had a very supportive pupil supervisor. I don't know how general or universal that is, but that's what happened with me anyway.
Thank you, Seth. Now, the next question is for all the panel members. So what societies, work experience, etc., would you recommend getting involved in as an undergraduate law student? So Nora or Chantal, whichever one of you would like to take that.
Okay, I think that meant me. Yes, I think the most useful thing, if you can, is probably to do mooting. For me personally, it was really helpful because I started out thinking the bar was a completely unrealistic idea for me. And then I realized I actually enjoyed mooting. I mean, it looks good on your CV as well, but I think particularly if you can do, bigger competitions or competitions judged by real judges, and you realize that, you didn't terribly embarrass yourself and you didn't die, then you'll definitely feel a lot more confident pursuing the bar further. Other than that, I believe some universities have pro bono initiatives, so that can definitely be something worth looking into. But don't worry if your university doesn't, because there are many ways to demonstrate an interest in law. I think things like essay competitions can help as well. So essentially demonstrate a strong interest. But I think the number one thing I would recommend doing is public speaking and mooting.
Thank you so much, Nora. So Seth, there's another question for you. This question states that I'm interested to hear more about your views on being selective with applications. I was led to believe that the bar had put huge emphasis on social mobility and diversity. In order to encourage accessibility to all areas of the bar, irrespective of background, would you recommend that I limit my applications only to chambers that hire people like me, given that I come from a non-traditional background?
So if it wasn't clear when I said before, when I was talking about looking and being realistic, talking exclusively there about your educational background. I'm also from a non-traditional background, and I wouldn't at all suggest that you should limit where you apply on that basis. And no chambers in this day and age will be looking at those sorts of factors. I do, it's tough, but I do stand by what I say in terms of, look, if you look at the profiles of some very, very top caliber sets, you will look at them and you'll see that a lot of the people there have PhDs when they're coming in, or they're coming in from industry and things like that. And that's not to say you couldn't go there and be successful, but I think it's important to know that you might be up against it, or at least to know, well, if I get to an interview, those might be the sorts of areas that I need to kind of put my best foot forward and show them, yes, okay, I don't have a PhD, I don't have further specialist training in a specific area of law, but I can make up for it. I would always, the other thing to say is you can be a very successful commercial practitioner, even if you don't have a completely stellar academic CV, but you might have to choose which chambers you apply to more carefully, or carefully to do that. The chambers I'm a part of, we actively seek out people who have life experience and may not have completely stellar academic backgrounds, because we value a bit of life experience. You can go to a set and even if you don't have a triple-starred first from Cambridge and a Harvard PhD, and then develop a commercial practice very successfully. But I think it's just about giving yourself the best possible chance to succeed, and looking at what's going to be the strength of your application, what's going to be the weakness of your application. But again, when I'm saying that, I'm talking about your academic and your professional and your work experience CV and nothing else.
Can I just add, sorry, can I just add to that? Because I think quite a lot of people have been talking about this, and I think it's a really, really important point. the reality is that there are so many people applying for pupillage, and in some ways the most difficult thing is getting from application to interview, just because the number of people you'll be up against. If you go onto Chambers websites and you look at the profile of their recent tenants, that's a pretty good indication of what a large number of people applying to those sets will have in terms of their academic background. Now, it doesn't mean that the Chambers are just looking for those people, but when they have a very limited number of interview slots, you have to ask yourself realistically if you can stand out on paper against all of those people who will be applying. Now, sometimes life experience or experience in a particular industry or very significant success in mooting competitions will raise your application form and will put you very near the top of that interview list. But there is a limit to how much you can jump up the list and jump over those people who do have those particular academics and experience, perhaps. Having said that, I think it's also important not to be too pessimistic. I have to say, Erskine for me was a slightly wild card Chambers, because when I looked on their website at the time I applied, which was 10 years ago now, they didn't have any young female members of Chambers. It looked from their website as quite an academic, serious Chambers, and I thought I didn't have a chance to get in there and it wouldn't be for me. And actually, when I went to interview, I realised it was just because they had a terrible website, and it was very friendly. And even me coming as somebody from a theatre producing background, and so not quite within exactly what they would normally recruit from, that wasn't a problem. I mean, I would probably say that if you have dream sets and you think you have a chance of getting in there and you will perform well at interview, there's perhaps no harm in putting a couple of your dream sets down, but be a little bit realistic in just making sure you have a slight range of Chambers as well.
Thank you so much, Chantal and Seth. Sorry, Nora, go ahead, please.
Yes, I'd also just like to add one thing to that, which is make sure that you research and actually do find all the Chambers out there that are doing your area, because I think a lot of people are influenced a bit by things like, the legal chic, most lists, which they really should have more Chambers on there because our pupillage award, but anyway, they don't. So basically, if I'd only looked at those lists, then I wouldn't have known that my set existed. And I think the issue is that lots of those very well-known sets really do have, almost exclusively juniors who got it first and then did the BCL or the Cambridge LLM. I got a 2-1 and I didn't get into the BCL, and I also didn't get into the Cambridge LLM. And at my set, most people have a similar academic background to me, some slightly different and some, additional work experience and so on. But I think that if I were offered, any other path, sorry, I'm very bad at sort of explaining this, but essentially I think I ended up in the best place for me and I'm incredibly happy. And I think it's important to see that there aren't only 10 or 12 commercial sets, basically.
Thank you so much to all the panelists. I think that's clarified a lot of the questions in the chat box about whether, what kind of environment you're applying to or fair treatment and everything. I think it's not really about fair treatment. The panelists just mean to say that you need to be a slightly bit more realistic with where you're applying, as well as applying to your dream sets, as Chantal did state, because some people might not have a good enough website at the time. But moving on to the next question. So did you ever consider working for the employed bar rather than working independently? Should we start with Chantal?
I didn't, but I know a couple of barristers who have, either after, but actually I think mostly after pupillage. Some of them are still there working for the employed bar. I think it's still quite unusual to do your pupillage as an employed barrister, but it's a very good option post pupillage if you don't quite get on with the set, or if you realise that the security of a salary is something that appeals to you. So I agree. I mean, I think probably none of us here can talk about it from first-hand experience, but certainly it's something that's always worth bearing in mind, and you can get some excellent work as an employed barrister. And people now move between the employed bar and self-employed bar in commercial law.
Thank you, Chantal. Nora?
Yes, I agree. It's definitely something everybody should keep in mind. I personally hadn't really thought about it. I think that perhaps because I was a student before and hadn't ever had a full-time job, I sort of didn't care as much about security, potentially, as some people would who have already had a stable career and who are sort of now changing and going into self-employment. For me, that wasn't really the main consideration. And I sort of knew the self-employed bar as the more traditional choice. And so that's what I went into. I didn't really think about it very much, to be honest.
Thank you, Nora. And Seth, is there anything you'd like to add to that?
No, nothing to add.
Thank you, Seth. Now, the next question is, what is the best way to find out about the culture of various chambers, since many pupilages are very hard to achieve currently, and they all say that they have a friendly and warm atmosphere? And who would like to take that question? Anyone? Chantal, would you like to take that question?
I sympathise, because I think it's very, very difficult for people applying for pupillage at the moment. I would normally have met a lot of students at this point at informal events, and you just haven't had that opportunity this year. I mean, I think all I can say is just take advantage of the mini pupilages and open evenings that chambers are doing. Have a look at the Chamber's student guide, which gives you some insight, although of course it is essentially glossy marketing. There are very few chambers that are not nice chambers to be in. I don't know many barristers who don't like their chambers, and chambers generally now work very hard to have an atmosphere that encourages everybody, that supports everybody, and that encourages people from a huge range of backgrounds and with a huge range of interests. So I don't think it's quite as scary as it might seem, because if you get an interview somewhere, you will get a sense of the set interview. And there's certainly nowhere really where I would say to people, don't go there, don't accept pupillage there.
Thank you so much, Chantal. So the next question is, have you all done an LLM? And if so, was it a generalized LLM or a specific LLM? So should we start with Seth?
No, I don't have an LLM.
And Nora?
I do. I did an international commercial law LLM at UCL. It's absolutely not necessary, but I think some people might find it quite helpful. So for me, it was because I didn't have any work experience. And for instance, if you want to show that you're interested in trusts, it's really quite difficult to do that, other than by pointing to academic experience. So I think for me personally, it was really helpful to be able to point to my dissertation and say, look, I've written this about trusts voluntarily. And you know, that's what I'm interested in. And I think it personally helped me, but I think that's really up to everyone. And obviously, it's something that financially can be quite difficult to do, which is why, again, I stress it's not required. But if you've got a particular academic interest that you want to pursue, then yeah, I can recommend it.
Thank you, Nora. And Chantal?
I haven't done an LLM, no. I think do it if you're interested in doing it, but certainly don't feel you have to.
Thank you, Chantal. And the next question is actually directed at you, Chantal. So what made you choose company law and insolvency, and how did Erskine accommodate these interests during your pupillage?
So we're a specialist set generally, so everybody really specialises in company and insolvency. I was probably similar to Nora. I was quite open-minded when I was applying. I ruled out criminal and family law, but other than that, I made quite a lot of applications to a range of different sets that mostly with a commercial chancery focus. And ultimately, I think I chose Erskine as the set because it was the one that I enjoyed my interview in. And my view was I enjoyed the law. It's academic. I found it interesting, but I didn't know much about it. But I was sufficiently interested to learn.
Thank you, Chantal. And the next question is, essentially you're all earning your own money. I'm assuming that's referring to being self-employed. Is that stressful or enjoyable? So let's go back to Chantal. What do you think about that?
It's both. I think most barristers had a period at some point last year where we were worried about money, and it wasn't quite clear how things were going to go. But actually, certainly from most of the people I know in the civil side, it hasn't been too bad. Ultimately, if you're choosing commercial civil law, you can do very well financially out of it. I mean, the pupillage awards are probably a fairly reasonable reflection of what you'll be earning in your first year or two of tenancy. And you can often earn a lot more than that quite quickly. So it's just really about learning to manage money and making sure you have enough set aside for tax and VAT and for rainy days.
Thank you so much, Chantal. Nora, how do you find it?
I don't find it particularly stressful, probably because I don't really have that many financial obligations at the moment. I mean, I rent, I don't have a mortgage. So at the moment, I find it quite motivating actually when you do a really big piece of work and you get paid a bit more than maybe you would have expected. So that's quite a good feeling, although I can see it being stressful at times.
Thank you, Nora. And Seth, is there anything you'd like to add?
Only to say, when you start, don't be afraid to ask your supervisor about, how much you think when I start earning, how much should I put aside for tax, all that sort of stuff, because everyone has to work it out. Everyone who becomes self-employed has to work out how they go about putting aside the money they need to save and all that sort of stuff. So just don't be afraid to ask practical questions of other members of your chambers. I think the only thing I would say is I had never had a worry about it at all. There was a sort of sharp intake of breath in sort of like March, as Chantal was saying, where you thought, oh, blimey, I don't have a security blanket really to fall back on here other than various like insurance things. But it's been absolutely fine. And you'd like to say if the civil commercial bar can survive this sort of thing, it would be pretty impervious to most other sort of disruptions, be that Brexit or whatever. They probably just increase work, as Nora was saying, as Chantal said, when there's a downturn.
Thank you, Seth. Would you like to add something to that? I noticed you were off mute.
Sorry, me?
Yeah.
No.
Would you like to?
Sorry.
Oh.
I was only going to say when Seth said ask someone in chambers about managing your money. Get an accountant during your pupillage year. They do very, very good packages and discounts for people in pupillage in their first few years of tenancy, and they're a specialist bar accountants.
Thank you so much, Chantal. Now, for the next question, they've asked, do you think it's realistic to get a pupillage with a degree from a university that isn't in the top 20, and particularly from somewhere like the Open University? Nora, would you like to take that question?
Yes, that's a fairly easy question, and the answer is yes, it's realistic. I'm basing that on people that I was on the bar course with that I know got pupillage. One, for instance, went to the University of Westminster and got pupillage. one went to the Open University and got pupillage, and there's lots of other examples like that. I mean, I will say that usually people who weren't in the top 20 universities tended to do quite well in terms of marks. So, you know, it's always a good idea to try and be academically as strong as possible. But yeah, I don't think it holds you back to any great extent, no.
Thank you so much, Nora. So Seth, would you like to answer this one? What were some things that you wish you knew before pupillage?
Blimey. Some things I wish I knew before pupillage. Well, just something that someone told me on almost my first day of pupillage, which I found very reassuring, which is this: in pupillage, it's almost impossible to really mess anything up too badly, as long as you ask for time. And if you don't know the answer to something, you say, I don't know the answer to that, but I'll find it out if you give me some time. Even if it's a judge, even if you've got to say to a judge, I can't answer that right now. Would you mind standing this matter down for 5 minutes? And I will get an answer for you. And then you have a telephone call with someone in chambers. And once you sort of know that, you know, if you don't know the answer, you'll just have to say, or say that you'll find it out. And provided you don't lie or mislead anyone, not really that much bad can go wrong. Because obviously the first time you stand up in court, it is very nerve-wracking. I had to disable the heart rate monitor thing on my watch because it kept pinging me and saying, are you having some sort of tachycardic event because you don't seem to be moving and your heart rate's, you know, obscenely high. But yeah, that's probably the one thing that helped me the most.
Thank you so much, Seth. Chantal, how often do you incorporate commercial awareness into your work?
I always find references to commercial awareness quite difficult. I think it's a concept that's often used by solicitors' firms a little bit more than barristers' chambers. I mean, for us, commercial awareness is really about thinking practically about the commercial needs of the client, and thinking practically about settlements, about the risks of going to court, but also about their particular business, for example, and being able to understand the way that their business works. And I suppose commercial awareness is also that the more general understanding of the landscape at the commercial bar that we've talked about. So Brexit, the insolvency work, the impact of COVID on businesses, which is not all bad. Some businesses have done very well out of it. So my advice would be not to get too hung up on commercial awareness as a standalone concept. Just take the time that you can to read the newspapers, to perhaps read something like the Times Law Supplement on a Thursday, and to read newspapers and just get an understanding of the world and start to think about how that might affect things if you're a barrister or if you're running a business at the moment.
Thank you so much, Chantal. And Nora, what is the standout experience from your application and training at Chambers?
I saw that question a couple of minutes ago, and I'm finding it quite difficult because there were a lot of experiences during that year that I think meant a lot to me. But I suppose the standout one in more ways than one was when I did my first hearing. So it was my second six, it was May 2019. And I was supposed to ask for an adjournment, which, is a very basic thing to do if you're going to attend court, but I was actually really nervous about it for about 4 days. And I went and I met my clients and they said, we wrote a letter to the judge and we handed it to the usher outside. We hope that's okay. And I said, okay, what does the letter say? Oh, it says we actually want to litigate this case today because we feel ready. It's like, I thought, I don't think I learned about this situation on the bar course. And then we sort of had a conversation and essentially the reason we said we wanted an adjournment was because we said we hadn't got the claim form and only learned about the hearing a couple of days prior when we got an email about it. And we also wanted to bring a counterclaim. And I said, well, you haven't pleaded a counterclaim. And, you know, we've got a couple of things that would be the basis of this counterclaim and you haven't got any evidence. And I sort of pulled out an old notebook and said, but all the evidence is in here. And then I sort of tried to explain that you should ideally have a witness statement and so on. And then we sort of quietly got the letter back from the usher and we got our adjournment, and I was against another pupil from Tanfield Chambers and we went back together and sort of made friends on the train. And then I arrived back at my chambers and my pupil supervisor happened to be standing outside with a couple of his colleagues, and he asked me if I'd got my adjournment and I said yes, and he gave me a high five in front of everyone. So that was a good day.
Thank you so much, Nora. Thank you for the example as well. It was really nice to hear about that. So Chantal, would you say there are more BAME applicants being accepted into chambers, or is there still a huge gap in terms of diversity?
I think there is still a huge gap. And I think it's a problem for the bar, honestly, and I don't know all of the reasons for it. And I wish I could sit here and say, yes, it's a gap that is closing significantly very quickly. But certainly at the commercial bar, that there are still issues with getting enough candidates from a variety of backgrounds into pupillage. I know the bar is trying to do things to respond at the moment, but we have to listen to people and we have to do more. And I certainly don't think it's a reason to put anybody off applying. But yes, I think people will find themselves in a minority at the commercial bar still at the moment.
Thank you for that, Chantal.
I don't know, Seth and Nora, what do you think?
I agree. I think there's just so much more to be done in terms of, especially at civil commercial bar. Being from a common law set, it does seem to me that the other areas in my set are more diverse. Family and crime seem to be ahead of us in terms of getting more diverse applicants.
Yeah, I agree. I mean, it's difficult for me to say because my set is quite small, so it might not be entirely representative. But we don't have that many tenants from diverse backgrounds. But I do think the situation's improving.
Thank you. Seth, did you need to convince Chambers about moving to the north, given you had lived in London? And what were some of the attractions of moving to the north, given the bar is very London-centric?
I didn't have to work that hard to convince Chambers, because although I lost my northern accent a long time ago, sadly, because I should say I was also a mature applicant to the bar. I did a degree, I worked in schools, I was in education for a year or so, did other things and then came in later. So I'm actually originally from Newcastle area, so I was able to sell that fairly easily. Broadly, if you are interested in applying to any of what the bar kind of slightly in an old-fashioned way calls the regions, so Manchester, Newcastle, Leeds, Bristol, it is worth being aware that they will want to see that you're not someone who's going to complete pupillage and then just nip off to London, where you always wanted to be. So it is worthwhile thinking when you're making your application, can I show that I genuinely want to live in this area? You know, especially if it's a set on the pupillage portal, because people will just stick in speculative applications. It's worth kind of showing a degree of commitment, or thinking about how you can evidence a degree of commitment to going to live in Swansea or Bristol or Berwick-upon-Tweed or wherever you're applying. And the second part about the attractions of living in the north, well, your money just goes much further, to be honest. And I live 15 minutes drive from some of the best coastline in the country, and a short hop into Northumberland up into the Cheviot Hills, and I do go to London quite often for my practice, or I did before COVID-19. You can get on the train there in 2 hours 45. It's not the worst thing in the world if you do it on the morning. So for me, I just thought the kind of work-life balance, not wanting to have to spend a long time commuting around London, having done that before, made sense. And like I say, yeah, your money goes much further. You can buy a house, etc., much quicker if that's what you want. I was older. If I'd been 22, 23, 24, when I came into it, maybe London would have been more attractive to me, but I kind of wanted to settle down a bit quicker, and I thought that living in Newcastle in the northeast would help me do that.
Thank you, Seth. Now the next question is, where do you recommend doing the BPTC? Nora, would you like to answer that?
I think usually people apply to the three big providers, BPP, ULaw and City, and from what I've heard, they're all broadly similar. So I find it relatively difficult to say anything about that, although there is now a new Inns of Court School of Law, and I have absolutely no first-hand experience of that, but I did recently have a mini pupil who is doing his BPTC there, and he was very happy with it because apparently they're sort of, they got quite lucky with their situation in that their first part of the course was always going to be online. So they had all the facilities in place. So apparently it's been very good, even in terms of COVID. So that's probably something I'd recommend to people. Other than that, I'd say it doesn't hugely matter. I would say that you should look at the scholarships that the providers offer as well, because you should always try and apply at the Inns of Court for a scholarship, but there's usually a smaller scholarship that you can get at one of the providers, and essentially I'd go to whichever one of them gives you money.
Thank you, Nora. Now, there are a couple of questions with the same theme about, whether you should go to a Red Brick University or Oxford or Cambridge, or essentially what chambers look for when it comes to applicants for pupilages, which all the panelists have already answered. So skipping to one of the questions that has been asked recently, would you be able to give us examples of your favorite moments in practice? Should we start with Chantel?
I think I was 2 weeks before a trial, and it was going to be my first High Court trial on my own. And we discovered that the defendant, so the person on the other side, had forged a document. And it sounds very boring, but it was actually really exciting because we got supposedly this document from another source, and we're comparing it and realized that he'd forged the date. And when you looked at it closely, you could see he'd done some really bad tip-hexing. That's the sort of thing that doesn't happen very often, but when it does, it's very exciting. And I was planning all my exciting cross-examination for him about forging the document. But unfortunately, he then accepted an offer to settle that we'd made 2 years earlier because he realized we'd caught him out.
Thank you, Chantel. Nora?
I've obviously got a bit less off practice to sort of to answer that question. I mean, it's only been a year and a half, but what I really enjoyed was a sort of longer fraud trial with my former supervisor. I'm his junior in that. And it's been going on since I started my second six. And we've got, I think, a team of very, very friendly people. I really like our instructing solicitors in that case as well. And just sort of growing, sort of developing that relationship with them, I think was really interesting, and seeing that case develop. So, for instance, it sort of started life as a freezing injunction and as an application for private examination of a former director of a company that had been defrauded. And then we had about 30 contested application hearings. And then we had a 2-week trial in June that was entirely remote because COVID, obviously. And now there are additional defendants that we've just started issuing against, because we've got something called an ALDI direction, which means essentially we can, if new facts come to light, we can bring further claims against further defendants. And I think while I do a lot of work on my own, and while that's very enjoyable, it's been really nice to have this one sort of consistent case in my practice so far.
Thank you, Nora. And Seth?
I did about a year on my, after about a year on my feet, I got briefed very last minute into a trial that my former pupil supervisor was on the other side of. And it was just, I mean, this happens so infrequently, at least to me, but I sat down with the papers and spent, you know, a long time going through them and just spotted something that turned the case completely on its head. And it came down to one question in cross-examination, and I knew if I got a certain answer that the judge was going to have to rule in our favour. It was it's not very glamorous. It was about the renewal of a lease in a Chinese takeaway, and asked the question. I got the answer I wanted, and I got to sit down at the right time. You know, you always get told in the BBTC, like when you get the answer you want, sit down. And it was probably that, because it just, I mean, those sorts of moments where you unlock something with one question just seem to happen so infrequently. And it happened to me once and I really enjoyed it.
Thank you so much, Seth. Well, that's all we've got time for today. And Chantal, Seth and Nora, thank you so much for giving up your time this evening and joining us tonight and for sharing your wisdom and experiences with everyone here. I'd also like to thank you, Gray's Inn Education Department, and everyone else who was involved in helping make this series come to life. Now, this was the last panel of the series, so we hope that, you know, the panels have helped you all and you all have found them useful and beneficial. Good luck to all of you on your journeys to the bar, and we hope to see you again soon. Thank you very much and have a lovely evening. I'll just pass on to Maureen to also say thank you and say a few words.
Thank you, Seth, Nora, Chantal. It was absolutely brilliant, and I'm sure your advice will be followed through and heeded upon, hopefully. And just thank you very much, and thank you to Marianne for assisting me with the panel, and to everyone that attended today. Have a good evening.